Good morning, Mr. Premier.
Good morning, Chair and Commissioners. Good morning, Chair and Commissioners.
We really had our knives out for you because at this commission we start at 9:30 exactly. But we were advised by the evidence leaders that you were here, after 8 somewhere there in the morning? But that you were directed to a holding area and that you were advised to come after it had been indicated to you to come, something like that. So we are not able to chastise you, even though we were really itching to do it.
Chairperson, if I may, considering what happened earlier in the week, I can imagine that you would want to chastise me, and I'm going to resist saying that we were put with our client in a holding cell whilst we were waiting to be called before you, but we are here now and we're indebted for the audience that you are giving us. Thank you, Chairperson.
Thank you. And I understand that you are moving a postponement application.
Yes, Chair, we are, but through the agreement with my learned friend, he will address you first, and then I shall address you afterwards with your indulgence, if that is all right.
Thank you.
Thank you,
yes,
Chair.
Mr. Shaskelson?
Thank you, Chair. Obviously, the decision is with the Commission, not with us, but we don't oppose the postponement application, and I'd just like to set out why, because it's not on the papers. Chair, you will recall that in the course of the litigation last week, in the course of the litigation, the Commission made a with prejudice offer to Mr. Carrim that if he needed more time, he could come on the 24th and 25th of February. And our view, and he clearly does he says he needs more time, and our view is that if he needs more time, and we made that offer, it would be poor form now that the urgent is behind us not to hold that offer available. The problem with the 24th and the 25th is that Mr. Carrim'S attorney will be on Hajj, and so he can't be here on the 24th and 25th. His team offered the 2nd and 3rd of March, which are the first dates after his attorney, the first available dates after his attorney returns to the country. Unfortunately, the Commission can't accommodate the 2nd and 3rd of March, but the first available dates for the Commission after the 2nd and 3rd of March are the 9th and 10th of March. And subject to the Commissioner's agreement, we have agreed with Mr. Premier that we will support a postponement to the 9th and 10th of March. Mr. Carrim has undertaken to furnish a statement by the 3rd of March. We have indicated that the difficulty, the potential difficulty with that is that once we see Mr. Carrim's statement, we may have to expand the bundle that has been given to him for questioning. Mr. Carrim's team understands that they will do their best, or they will certainly meet the 3 March deadline. If they can do it sooner, they will. From our side, we will ensure that any additional documents are made available to Mr. Carrim's attorney within 48 hours after we receive the statement. So subject to the Commissioner's agreement, we would ask for the postponement to be granted and a ruling to be handed down in those terms, that the matter's postponed, or Mr. Carrim is excused and directed to return to give evidence on the 9th and 10th March, that he will furnish a statement to the Commission on or before 3 March, and that if in the light of the statement the Commission wants to add any documents to the bundle that he has already been provided with, they will do so within 2 days of receiving the statement, 2 working days.
Mr. Chaskowson, as it is often said in the court context, an application for a postponement is not to be had merely for the asking. The applicant mentions having been furnished with certain documents. I forget the number of days, but basically the point being that very close to today. Do you want to just give us the factual position in that regard?
It is correct that the bundle of documents for questioning was furnished to the applicant, I think it was Wednesday afternoon. Yesterday afternoon. That bundle is very bulky, but the bulk is misleading because it runs to 397 pages, but in truth, about 340 of those pages are documents which were annexed to the chats between Mr. Carrim and Mr. Madlanga, which were just medical surveillance authorization forms, in respect of which Mr. Carrim and Mr. Madlanga were communicating. Now, those forms are not documents, the contents of which are going to be relevant to, or are going to be interrogated. It's merely the fact that approximately 350 pages worth of, let me not overstate it, approximately 320 pages of medical authorization forms were exchanged between the parties. So it is the fact of the bulk of the document as opposed to the contents of the document that are relevant. Having said that, neither Mr. Carrim nor his legal team may have been certain that that was the case. And so I think he might have understandably have been taken aback at receiving all of these documents yesterday.
May I find out why the documents were not given to the applicant or his attorneys earlier than yesterday?
Well, there are two answers to that question. The first is that the chats and the rest of the annexures that have substantive content that the Commission will be interrogating were given to Mr. Carrim sometime last year, I think it was. At the time, we thought that there was no purpose in adding these 320 pages because we weren't going to refer to the content of them. In advance of the hearing, it occurred to us that the fact of the 320 pages was significant. I must indicate as well that there are certain additional pages which were exhibited by Mr. Mokhotsi, or exhibited in the questioning of Mr. Mokhotsi, pages 368 to 397 of the bundle, which were specifically given to Mr. Carrim for the first time yesterday. Which were specifically given to Mr. Carrim for the first time yesterday. However, back in, I think it was November or December, when Mr. Carrim was asking which witnesses have implicated Mr. Carrim and which evidence is relevant in that regard, he was directed to the evidence of Mr. Mokhotsi and the annexures to Mr. Mokhotsi. We should, I readily admit, have nevertheless prepared this bundle earlier and made it available to Mr. Carrim earlier. In the chaos around the urgent application, it didn't occur to us to proceed as though matters were going to, as though his evidence was going to be heard on Friday until the ruling came down yesterday. But we were at fault in that respect. And
just to be sure I understand, Mr. Chaskelson, the difference between the 397 and the 320, that is the 77. Are you saying before yesterday, Mr. Carrim was aware of those? I just want to be sure that I understand.
Mr. Carrim he hadn't pertinently been given these documents. He had been informed you were implicated by Mr. Mokhotsi. Mr. Mokhotsi's, the transcript of Mr. Mokhotsi's evidence is here. The exhibits to Mr. Mokhotsi's evidence are there.
So would the 77 be part of that?
The 77
is part of
come from the exhibits to Mr. Mokhotsi's evidence.
Okay. And did we at any stage indicate to Mr. Carrim or his attorneys yesterday or soon thereafter, which I don't know when that would be, today I guess, was it indicated that the 77 are documents that he, Mr. Carrim, in fact, was already advised where they are? Or rather, was he advised that you have been alerted where these documents are a while back?
No, he wasn't. He was given the bundle with no covering explanation yesterday.
Thank you, Mr. Chaskelson. Yes, Mr. Premier.
Thank you, Chairperson. May I start with some housekeeping, if I may? Last night, via email, we served on the Commission an unsigned copy of the affidavit. We now have the signed copy of the affidavit. It is identical. It's just so that the Commission has the signed copy so that the box under oath is ticked. And if I may ask that we can give that to the Secretariat so it finds its way to the Commissioners.
Thank you.
Thank you, Chair. Chair, may I just say this? We fully understand that a postponement application is not there for the asking, but I just want to draw attention to what my learned friend, Mr. Chaskelson, just said in response to your questions, Chair. You asked, were those 77 pages given? And my learned friend effectively said they were, but not pertinently pointed out. And the reason I mentioned that is because even though my client received bundles previously, my client's correspondence, which gave rise to the urgent application earlier this week, was to try, as you would understand, in trial settings, to limit the scope of inquiry so that instead of my client having to face a bundle initially of 2,000 pages, then 4,000 pages, we knew what it is we had to deal with. And now for the first time on the record, we hear that of the 400 odd pages, it's only 77 that matter. And so I have to raise the prejudice that my client has faced throughout this process. And of course, I'm not re-arguing the urgent.
Is the situation you are facing, though, not the function of the attitude of the applicant, including his attorneys for that matter, because reading the judgment and in fact being aware of the exchanges that preceded that, according to the judgment of Fisher J, the attorneys refused to even accept service of a subpoena on them and insisted that serve on Mr. Carrim, you are not serving on us. And also the judgment, I will not say anything that's being said by the commission. I will emphasize what the judgment says. The judgment, in so many words, of course I'm paraphrasing, says that the applicant and indeed his attorneys were obstructive, and the idea was simply to avoid coming to testify before this commission. So is it not so that the function, or rather the situation the applicant now finds himself is a function of that obstructive attitude or behavior? Because one should look at what the evidence leaders have done or failed to do in the context of what was thrown at them.
Thank you, Chair. May I start at your conclusion? And I'm going to respectfully disagree with you, Chair, on the basis that my learned friend, in talking about the internal processes of the Commission, to narrowing down the bundle and only serving that bundle, which clearly then narrows the scope of inquiry to the extent that that implicates my client, only happened yesterday. And without rehearsing the merits or demerits of the urgent application, you, Chair, will know pertinently that that was one of the issues raised in the urgent, where the reason for the interdict was to say, comply with your own rules, give me the bundle, tell me how I'm implicated, so that I can prepare my witness statement and I can come here. Of course, Fisher J. is entitled to make the observations that she did of obstructionism, and all I will say, without going back to that, is that the attitude of the attorneys has always been that our client has to come and testify in front of this commission, but he cannot be ambushed, and until such time that the commission complies with its own rules to properly define the scope of inquiry, he would then be prejudiced as a result, and the resistance put up by the applicant's legal team was to ensure that the outcome we're talking about here today, potentially if the postponement is granted, could have been achieved. So with all due respect, Chair, I would say that the true obstructionism, in light of the fact that now we have the bundle, which we were asking for from last year already, not a 4,000-page bundle or a 2,000-page bundle, but this very thin bundle of only 77 documents, demonstrates with all due respect that the Commission's legal team, and of course I don't mean any disrespect to my learned friend, but the Commission's legal team could have defined the scope of inquiry sooner. And actually, if the Commission were willing to play ball with my client and not start from the predetermination that he's only objecting because he doesn't want to testify, then maybe we could have reached this negotiated outcome last year already, and my client could have testified.
But quite late in the process, an offer was made, an offer that I think should have taken us to where you say that point should have been reached last year already. And all there was, and again I rely on the conclusions from the judgment. On that as well, there was interrogatory after interrogatory after interrogatory, as long as an arm and a leg.
Chair, I can accept the view that you put to me, but you will remember that in the context of that attempt to reach the dates, the 24 February dates, if that's the dates that we are talking about, at that time we still didn't have the bundle. So the objection as to why the offer was rejected at that time and the urgent was persisted with is to say, all you're doing is you are changing the hearing of the evidence date from the 6th to the 24th. But the prejudice, and Chair, considering your previous rule, you don't need me to tell you anything about fair trial rights and adequate opportunity to prepare and how that relates to Audi. That's the prejudice that we would have faced anyway, because my client would have come here without the benefit of the bundle, without the benefit of knowing what case he has to meet, and then, and again I'm choosing my words carefully, face a potential ambush. And so insofar as that offer was rejected, and even if, Chair, you would disagree with why that was rejected, I hope you can understand from our side that the consistency is that it wasn't to achieve an obstructed outcome, but rather to ask the Commission to simply comply. And that's why, Chair, now that the documents have been given, we know the case to meet, that prejudice about knowing the case to meet has gone away, but we have inadequate time to prepare because we were only given the documents less than 24 hours ago. So again, and without going into the history of the urgent...
I interrupted you. You were making a point. I hope you've not forgotten it. You are responding to me now. I've heard you.
Thank you.
So you may go back to the point you were making.
Thank you. May I just say one last thing, Chair, because you raised it. You raised the issue of the attorney being obstructive regarding personal service. Now, I know that's not an issue in front of you per se. That's a conclusion reached by Her Ladyship Justice Fisher. All I would point out is that according to the Commissions Act, Section 3.2, if I'm not mistaken, regarding service of commissioned documents, that is supposed to happen in terms of Section 14 of the Criminal Procedure Act. And I'm looking at my junior, Mr. Casey, in case I am mistaken about this. And that section in the Criminal Procedure Act requires personal service. And so Her Ladyship Justice Fisher is entitled to say whatever she wants to about the obstructionism or otherwise of the attorneys, but with all due respect, it's not as though the attorney was acting without cause, particularly in circumstances where now we know what the case is to meet. We're here, and we're just asking for a little more time to prepare. So, Chair, that was my engagement with you and my response to you, but realistically, I've covered all of the comments I wanted to make because you've pertinently put the issues to me. May I just consult my attorney to obtain an...
Just before that,
apologize.
Maybe what I'm going to raise will indeed also require you to confer with your attorney on it. I understand that one of the reasons given for the postponement, and indeed, in fact, for a date as far as the dates that that Mr. Shaskleton gave us.
9 and 10 March.
9
Chair.
and 10 March, yes. Part of the reasons is that your instructing attorney will be attending or going to the Hajj, something that I respect for reasons that are obvious. Again, for what you referred to, my previous position, I should respect that. But what I want to find out is whether there isn't another attorney who would be able to attend to this from the attorney's firm.
Chair, may I just, if I may respond?
Yes.
So, the correct position,
Yes.
and I understand that these are not recorded in letters or whatever the case is, and I hope the Commission will take me at my word, is that Ramadan is expected to start on either the 18th or the 19th of February, depending on when the moon is sighted. We initially offered the Commission 2 and 3 March because that was actually the dates when our legal team was available. As my learned friend has said, the Commission is not available on 2 and 3 March, and the 9 and 10 March are actually the dates when my lead instructing attorney will be traveling for Hajj. Umrah, I apologize. There's a difference between Hajj and Umrah depending on the timing in which you go to Makkah, but be that as it may. He will not be here, but we are nonetheless prepared to come with other attorneys and the council team to ensure that there's no disruption. So even though the senior instructing attorney will not necessarily be here, we will be here, and I just want to emphasize that we will be here.
There was something you wanted to take
Yes, I just wanted to
on?
check before I lose my day fee. Chair,
We had to confer for quite a while, but let me listen what you wanted to confer with your instructing
Yes.
attorney about. Yes.
And Chair, then in respect of the arrangement that Mr. Chaskelson set out regarding the filing of the witness statement, the update to the bundle, if we put in the witness statement earlier, we'll get the bundle earlier, and so on. We concur, and assuming that the postponement is granted, we agree
We
with
were
that.
actually conferring about the date by which the witness statement should be filed, and we were thinking that if you actually offered the 3rd of March for a hearing, then it means you are in a position to file your witness statement before the 3rd of March. What we are worried about is the supplement 48 hours after the witness statement has been filed. That's getting us very close to the date of hearing. We as commissioners also need time to read everything that has been filed. Don't you want to just a few days before, maybe the 27th of February? I see your instructing attorney shaking his head. But
Sorry, Chair.
just make an offer earlier than the 3rd,
Can we do
if
it
possible.
Can we do it at 6 a.m. on the 3rd?
On which day?
6 a.m. on the 3rd, the earliest you could do.
Could I just ask for a clarity, please, Chair? Do you want us to tender that date now on the record? Because my only difficulty, and although I understand I have a legal team available, is that I'm in the NHI litigation that entire week, and so I, as the leading counsel who need to be involved in the preparation of the witness statement, am already under significant pressure because of that impact. May I just have a moment to confer with my attorney, please, and I will then place the answer on the record?
Yes, we would like to have the date now because we want to make it part of the order. Do you want us to adjourn for a few minutes and then you indicate to us? I will not state a time of the adjournment. We'll just adjourn and then you'll indicate to us.
I think that I'll be indebted for that because we also need to talk to our client that we can talk about dates for prep and so on.
Yes.
I would be indebted.